Okay, awesome. Well, hi, everybody. Welcome to the third workshop for ACM Impact. Today, we are going to be talking about big tech regulation. And so first, to just give you guys an overview, we're going to talk a little bit about the debate about big tech regulation, so the basic pros and cons. And then we're going to get into some case studies and some specific ways that we've tried to regulate big tech in the past. So to start, the pros of regulation, one of the really big ones is that you can't really expect corporations to act in the public interest. Companies are going to act in a way that helps them maximize profit. And it's supposed to be governments that are looking out for public interest and trying to protect rights and all of that. And that's the reason why no other major industry isn't regulated. If you look at this graph, you can see that the number of regulations that tech has is very low compared to pretty much every other sector. And so there's a reason for that. It's because in all these other industries, we found that we need regulation. Another argument is that the stakes are really high. Issues like basic democratic processes and the right to privacy are at stake. And normally we would trust the government to protect those rights for us through different regulations. And even big tech companies support regulation. Companies like Alphabet, Amazon, Facebook, they've all expressed support for various types of regulation. But that last point is a little bit sus because those are big tech companies who are advocating for their own regulation. And so some people would say that should actually be a con because companies are trying to support regulation so that they can pull the strings behind the scenes and make sure that they have loopholes that they can jump through later on. Okay, so against regulation, one of the really big arguments is that politicians might not understand the technology that they're trying to regulate. We saw that very clearly in the super cringy Facebook hearing where senators were not able to understand how Facebook works. And kind of along those lines, tech moves a lot faster than our government. It takes a really long time for a bill to be proposed and then become a law, whereas the tech industry is very rapidly evolving. And so it's going to be really hard for our government to keep pace with technology, which might mean that there's a better actor who can put regulations on tech companies. And then some more arguments against regulation. One is that big tech is inherently monopolistic. So some people would argue there's never going to be 5 different search engines that someone would switch between depending on their mood. If people stop using Google, that's because there's a better product and then everyone's going to use that better product. Tech is not set up for multiple companies to coexist. And then another point is getting rid of big tech could stifle innovation. If you look at the companies that are investing the most in research and development, they're pretty much all big tech companies. And so if we try to break up those companies, then we're going to lose a lot of those investments. And then that could lead to fewer discoveries being made in tech. Okay, so now we're going to get into some of the ways that we've tried to regulate tech in the past. And the first way is with antitrust regulation. So way back in 1998, Bill Gates had to testify before the Senate Judiciary Committee. And a bunch of different people testified against him. One of them was Scott McNealy from Sun Microsystems. And his main point was that Microsoft was violating antitrust laws because they didn't have enough competition. McNealy was kind of a savage and was not friends with Bill Gates. These are some of the quotes I found of things that he said about Gates and Microsoft that I thought were pretty funny. Okay, and then going back to the case, the Department of Justice and 20 other states filed a lawsuit against Microsoft saying that they'd violated the Sherman Antitrust Act, which is from 1890. And if any of you guys took APUSH, you might remember this was like at the time of robber barons and like big railroad companies and oil companies. So it was definitely not designed with tech in mind, but the reason they picked it is because it very generally prohibits monopolies or the intent to monopolize. And Microsoft and the Department of Justice went back and forth for a while. At first, Microsoft lost the case, but then they won an appeal. And eventually they reached a settlement that didn't involve breaking up the company. So on the surface, it seems like Microsoft got what they wanted. They were not forced to break up, but they did suffer a couple consequences. A lot of people say this is why Bill Gates had to retire in 2000. And also Bill Gates says that this is why Microsoft phones never fully took off, because they were so focused on the antitrust case. Okay, so then if we have all of these big tech monopolies, what is the right course of action? Should we be trying to split up these monopolies with laws like the Sherman Antitrust Act, or should we leave them be, or is there some sort of middle ground we can take? I'm going to turn it over to Arjun to talk a little bit about that.
Okay, so one approach that some people have talked about is going in gung-ho. Let's break up big tech. So backers of this include Senator Elizabeth Warren, and her biggest proposal is that tech companies can either be a player or an umpire, but not both, which means if you're running a platform, you can't be a participant in that platform. And on the surface, it kind of does make sense, because if you're like Amazon and you're a marketplace, should you also be allowed to have your own label like Amazon Basics or something like that? But so of course, platform utilities would be barred from owning any of the participants. But the issue with this approach is that it makes a lot of stuff illegal. Senator Warren herself said that the iOS App Store and the Xbox Store themselves would become illegal. And that's why breaking up big tech for the moment is mostly considered to be more symbolic than an actual statement of intention. So we can also look at what the European Union's doing, our transatlantic regulatory bodies. What they've done is they've imposed huge fines on big tech companies, like to the order of billions of dollars. So what their antitrust SAR alleged was that Google was involved in anti-competitive practices, which means that Google ranked Google results first. So if you're looking for restaurant reviews, they rank their own reviews before, say, those of Yelp. So is there a middle ground solution possible here? So that you could potentially force big companies to share their data with smaller ones, and that could potentially lead to better data, better products, and more competition. You could also let bigger platforms not promote their services on other platforms, which would mean a kind of a separation of concerns. But of course, these are super long-term solutions, and they'll involve huge amounts of regulation. Big laws need to be written, and they'd have pretty big consequences. And so for the time being, people have talked about mandating data portability, mandating data interoperability, and prohibiting companies from combining data across different platforms to potentially prevent monopolies. For consumer protection laws, I'm going to turn it back over to Nisha.
Okay, so we talked about antitrust laws. Another way through which we've been able to fight against big tech is through consumer protection laws. So the FTC is the Federal Trade Commission, and they are the big organization responsible for consumer protection. And they have pretty broad responsibilities, but in the context of tech companies, this could include things like not following a published privacy policy, or companies that don't maintain security measures, or companies that have misleading advertising. So, as you probably remember, in April 2018, Zuckerberg testified before the Senate after the whole scandal with Cambridge Analytica. And if you want to know more about data privacy, you should definitely check out our previous workshop, which is all about that. But long story short, the FTC ended up fining Facebook $5 billion for deceiving users about their ability to control the privacy of their personal information. And $5 billion might not seem like that much for Facebook, but if you look at this graph, you can see it is by far the highest penalty that has ever been put in place for privacy enforcement. So this was a pretty big deal and was pretty unprecedented. Okay, so another consumer protection law that was recently passed is the GDPR, which is the General Data Protection Regulation law passed by the EU. And it has a whole list of points that companies have to comply with in order to operate within the EU member states. So it's at the time, it was the broadest data protection law that was put into effect. So it was a pretty big deal. And then even more recently, we've seen the CCPA, the California Consumer Privacy Act, which just went into effect this year. And it allows any Californian to do three things. First, they can see all the data a company has saved on them. Second, they can see a list of all the third parties who have access to that data. And then third, they can opt out of allowing companies to sell that data. And this affects any site available to California residents. So even though it's a state-specific law, it has pretty international impact. And then Prop 24 just passed, and that expands and builds on the CCPA and aims to kind of close some of the loopholes that were exposed in the CCPA. Okay, and then that brings us to where we're at today with Section 230. I'm going to hand it back to Arjun.
Yeah, so Section 230 is basically about this law about whether tech platforms should be held accountable for the speech that's on them. And Congress hates it because that's basically how they avoid liability for all of the shenanigans that goes on their platforms. So where did this come from? And to talk about that, we have to go back to this basic liability definition that varies across publishers, distributors, and platforms. So publishers are accountable for what they publish. So you think news publishers, book publishers, if they say something libelous, they are liable for it. Distributors, so like a bookstore, aren't as liable because they make the argument that, hey, we can't read everything that we sell, we can't read everything that goes through us, so it's a lot harder. Platforms also do not have any liability at all. Now, this changed in 1995 with a super important lawsuit of Stratton Oakmont versus Prodigy. So Prodigy ran an online chat forum called Money Talk, and someone on that platform alleged that Stratton Oakmont were doing some shenanigans with the launch of an upcoming IPO. So does the name Stratton Oakmont sound familiar to anyone? I'm going to check chat real quick. Okay, well, Stratton Oakmont is the firm that was in The Wolf of Wall Street. So Stratton argued that because Prodigy was censoring people, Prodigy mandated that the chat on the platform was family friendly and didn't have any swear words. So what Stratton argued was that if you're going to look for bad words, you're also liable for all of the speech. And so the courts agreed with Stratton and they said, you know what, Prodigy, you guys are responsible for these libelous claims on your platform. So this created some strange incentives because all of a sudden, if you're a platform, it would have been better for you to not control anything at all as opposed to moderating swear words and other potential hate speech on your platform. So if you were to say something along the lines of, sorry, this is the Christian server, so no swearing, you'd open the door to potential libel lawsuits. So you'd have to be careful about that. Okay. So 26 words that created the internet. In 1996, there was bipartisan action in Congress to overturn this decision, and they passed the Internet Decency Act. And what they said was that no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. Basically, what this means is that if you're a platform, you are not responsible for what your users say. You're just a platform. And this regulation literally helped create the internet because this meant that there could be the concept of a social internet. And many of the biggest platforms that we see today are in some ways these social networks. Um, so you might be thinking, Congress acting definitively to overturn a decision, removing regulation. This is what we're all about here. Bipartisan action, let's go. This law is probably like the best thing in the world. Maybe not. So what's the deal with 230 right now? And to compare it, so Section 230 came in 1996, the same year that actor and lead star of HBO's Euphoria, Zendaya, was born. And so we've graphed their popularity. And as you can see, 230 isn't doing very well. In fact, actor, singer, is she a singer? And the lead star of HBO's Euphoria, Zendaya, is performing much better in the polls. So how did this come about? And there's a lot of criticism. This guy doesn't like it too much. He said tech giant should not be shielded, and this guy didn't like it much either. He's also saying that he'd like to revoke Section 230. So both of these guys don't seem to like 230, and I apologize for my Bernie impression. Uh, and and there's this guy as well. This like one day he just tweets revoke 230. So it's assumed that he's talking about Section 230, but he could be talking about like the number 230 in general. So we went from bipartisan approval of this to bipartisan hatred. And how did that happen? So the criticisms that I've seen of Section 230 seem to fall into two fairly convenient buckets. It's either big tech is going too far, or big tech isn't doing enough. And so if you look at the big tech is going too far bucket, some people have been saying that they're allegedly against conservative opinions, they censor these conservative opinions, and that big tech, so platforms like Twitter and Facebook, should lose their 230 protections if they continue to label content as either misleading or false or against like civic election spirit or something like that, since they won't be neutral platforms anymore. And there's been a lot. But the CEOs didn't really seem to care too much about that. We have an image of Jack Dorsey reacting to this. That's definitely Jack Dorsey. Um, but that's not really an issue of 230. So if Twitter says that someone's tweets are misguided, Twitter has the right to do that because as a corporation, it has First Amendment protections to label whatever. They don't have to carry anyone's speech. They get to have their own terms and conditions. Section 230 is literally just those 26 words. They just say, you are not responsible for what your users do in a way. And algorithmic bias is super important, but it's not a 230 issue. That's like, that's a whole different thing. So there are more, in my opinion at least, more valid, more grounded criticisms when you think about if big tech is not going far enough because they are protected. So do they have too many protections? And so there are two important cases, Grindr versus Herrick and Facebook in Myanmar. And before I get into those, the next few slides contain some depictions, discussions of harassment and violence. I've kept it fairly high level, but just in case. Um, so yeah, there's a man called Matthew Herrick who was harassed by a former partner who set up a fake profile in his name. So this partner used photos that he had of Matthew, and over a period of months ended up sending over like 1,000 men to Matthew's house, and they harassed him in a way. But Grindr did not take down this profile. They said it's not our responsibility to do that. Because we have 230 protections, we as a platform are not responsible for what our users doing. And the Supreme Court sided with them. And in fact, they said, this is literally exactly what 230 is made for. You are not, as a platform, Grindr is not responsible for the action of some rogue users. There's also Facebook in Myanmar, and Facebook in that country is said to have replaced the news. So it's a primary source of news for a lot of people. It's a primary source of, it's a big source of social interaction for a lot of people. But allegedly, or Facebook admitted, in fact, that it was used to incite violence against the Rohingya minority by the Myanmar military. So they created fake profiles and they spread false information. And this information was then algorithmically spread to a whole bunch of people. And yet there's no clear path to legal action against Facebook because of 230. So this is no longer just on the internet. This is real world harassment, real world violence. But these platforms are in no way accountable for that because of 230. So where do we go from here? And that's a pretty deep question to ask, because in a way, this rule has been responsible for the creation of the internet as we know it, but it's also kind of led to this real world harm. So there's the PACT Act, another bipartisan act introduced in the Senate. So it requires explanations of moderation practices, and it requires that platforms remove court or content that has been deemed illegal by a court within 24 hours. And it also lets the Department of Justice and Federal Trade Commission enforce federal laws on platforms. So in a way, that's kind of like, it sort of revokes 230. And there's a good question. Instead of repealing 230, can we create exceptions for it? And that has actually been done. In 2018, they passed an act for victims of human trafficking, and saying that companies are responsible for content in the sphere of human trafficking. And if that happens, you definitely have to remove it. You will not be allowed to get away. But the question is then, can't they just like make a whole bunch of exceptions and effectively dilute the law? And that's a big worry that a lot of freedom advocates have on the internet. So the support for the PACT Act, Mark Zuckerberg and Jack Dorsey kind of support it. So they haven't explicitly said that they do. So please do not sue me. But they have said that they both expressed support for bipartisan laws that create some exceptions and increase accountability, which kind of aligns with the PACT Act. And the PACT Act is bipartisan, which is always good, so it has a decent chance of passing. The criticism is that mandating moderation may run afoul of the First Amendment. You cannot force these platforms. You may not be able to force these platforms to tell people about what their regulation stances are, what their moderation numbers are. You may not be able to force them to do that. And then another criticism is that the super big firms, they have the money, they have the manpower to hire people and weather the storm, but medium-sized tech firms may not be able to comply as easily. I used the description medium-sized kind of loosely, but Reddit and Craigslist have said that, you know, if the PACT Act were to pass, we would have to completely overhaul our moderation structure. We'd have to overhaul our business model, because the PACT Act kind of mandates this centralized moderation, which at the moment Reddit mostly has decentralized moderation in the forms of a whole bunch of smaller communities. Okay, so we have some predetermined-ish discussion questions. Nisha, do you want to go over those?
Yeah, sure. Okay, so the first set is about big tech and antitrust laws, some of the Microsoft stuff that we talked about. And so some questions to think about. Is there competition between social network platforms, or enough competition? And if you disagree with the policies of one social network, is it possible to simply switch to another one? Do the benefits of big tech, some of the stuff like the investment in research, outweigh the downsides, like the human rights issues? And should the government be responsible for regulating big tech, or is there some other actor that could do a better job? And then with speech, misinformation, and the internet, so a lot of the Section 230 stuff, should internet services moderate hate speech? And if so, how can they define what is hate speech? Do internet services have a duty to prevent the spread of misinformation, and or does this responsibility lie with the users? And does Section 230 give tech companies too many protections? So those are just some questions to get you started. We're going to put you guys in breakout rooms for 15 minutes, and each room is going to have at least one facilitator who has all these questions. So don't worry if you don't remember them all.
Okay, yeah, I'm going to stop sharing for a minute and assign breakout rooms real quick. Are there any questions in the meanwhile? I haven't looked at chat in a fair minute.
Oh yeah, if anyone mentioned anything in the chat that we didn't address, definitely you can bring that up now.
Someone asked, instead of repealing 230, can we create exceptions for it?
Oh, I think I kind of touched on that.
Okay.
But I think so that kind of has been done for some cases. Like they passed a modification in 2018 called FOSTA SESTA or something like that, which did roll back some protections. But other than that, I think there are some concerns about basically whether by cutting away protections, if you keep carving out exceptions, eventually you'll just dilute the law as it is. Okay.
There's
Okay.
another question.
Oh yeah.
Asking if you can go over the main provisions in the PACT Act again.
Oh yeah, sure. Give me a minute. Yeah, so the PACT Act doesn't completely tear away Section 230. It's not a repeal as a whole. It's kind of along the lines of just let's sort of make some small changes to it. And what they've really done is they've said you have to be transparent with your moderation practices. You have to explain what they are to everyone. You have to make that data public. That kind of ties in with the first criticism that we saw that there's censorship of these opinions from one side of the political spectrum. So to deal with that, they've said you have to make these moderation practices transparent with everyone. And as for removal of illegal content, they said you will be liable now if a court says that something is illegal and must be removed. You have to remove it within 24 hours. And this is kind of where the size issue comes in, that some companies may not have this, the size and the monetary ability to deal with this. So this regulation may be burdensome on smaller, more upcoming companies. And they also said that companies should let the Department of Justice and FTC enforce federal laws on platforms, which means that the Department of Justice and the FTC would be able to hold both the platforms and users to account for content on these platforms. So there's no longer the free license as such. Is that okay? Okay, sweet. Okay, so I'm creating breakout rooms. I think they should be, everyone should be invited to a room.
Yeah.
Okay, sweet.
Wait, do they all have a facilitator? I think they should,
so.
just based on the numbers.
I use the pigeonhole principle.
Oh my God. Okay, I'm gonna go then.
All right, cool.
Okay, see you guys. There's a feedback form over here. Attendance code, Zendaya, and feedback form. Truly, yeah. Yeah, I think like with the passing of the CCPA and like Prop 24, there's going to be like there's going to be more. I hope there's going to be more of a national conversation on like regulation and data privacy laws and just like transparency in terms of like algorithms and what they do. So I hope that comes around.
Yeah, but in the end, I think that if people like, it's going to be